Hello, hello. Oh, 2 minutes delay. Around. That wireless no.
Yeah.
Hearing.
You want it to be screened. No. Good morning, ladies and gentlemen, and a warm welcome to all the esteemed dignitaries, distinguished guests, respected faculty members, and dear students. I am Aisha Manal, a final year student of SDM Law College, and it is an absolute honor to stand before you today as we embark on this enlightening journey of discussion and knowledge sharing at our national seminar on reproductive rights and legal framework addressing population issues. So to begin this auspicious occasion, let us seek the blessings of the Almighty with a prayer. I'd like to invite Anjali and Vindhya to lead us in prayer. I also request everyone to kindly rise up for the same.
शम्भो गिरीश सुरपूजितकामवैरिं गौरीश शङ्कर महेश्वर विश्वहेतो शम्भो गिरीश सुरपूजितकामवैरिं गौरीश शङ्कर महेश्वर विश्वहेतो धर्मस्थलेश सकलेश दयापयोधे श्रीमञ्जुनाथनितरा कुरु मङ्गलं मे धर्मस्थलेश सकलेश दयापयोधे श्रीमञ्जुनाथनितरा कुरु मङ्गलं मे कुरु मङ्गलं मे कुरु मङ्गलं मे कुरु मङ्गलं मे.
Thank you for the beautiful invocation. May this event be blessed with wisdom and meaningful discussions. I now request Dr. Annapurna Sheth, our seminar convener, to welcome the gathering and our esteemed guest and share a few words about her journey and accomplishments. And as a part of the welcome address, Dr. Annapurna Sheth will also shed light on the theme of today's seminar, that is, reproductive rights and the legal framework addressing population issues, highlighting its significance and the legal dimensions surrounding it.
A very good morning to respected dignitaries on the dais and all gathered here. It gives me immense pleasure to extend a warm welcome to you all to the one-day national seminar on reproductive rights and legal framework addressing population issues conducted in association with ICSSR SRC. Today we have amidst us Professor Dr. Bismi Gopalakrishnan, who is currently the Registrar of Mahatma Gandhi University. She also heads School of Indian Legal Thought, Mahatma Gandhi University, Kottayam, Kerala. Ma'am is alumnus of the United States Department of State Bureau of Educational and Cultural Affairs, Professional Exchange Program, International Visitor Leadership Program, and has 27 years of teaching experience. She has published 4 books, 40 research papers, and guided 10 PhD theses. It's my honor to welcome you, ma'am, who have taken time from your busy schedule to grace this occasion by inaugurating the seminar and delivering the keynote address. On behalf of management, principal, staff and students, I now request our principal Dr. Tarnath sir to honor and felicitate Professor Dr. Bismi madam. Welcome you, ma'am. Thank you, sir. I also welcome our 2 distinguished resource persons of today's national seminar, Professor Dr. Shashikala Gurpur, Dean Director, Symbiosis Law School, Pune, and Dr. Kumuda Rao, Associate Professor, A.B. Shetty Institute of Dental Sciences. I welcome our beloved principal, Dr. Tarnath sir, who has always been a guiding light and a source of inspiration to all of us. Your continuous support and visionary leadership has played a pivotal role in shaping the success and growth of the institution. I welcome all the moderators who have accepted our invite, Vice Principal Dr. Balika, HOD of Law Mrs. Sarika Rai, HOD of Humanities Mrs. Ujwala, and all faculty members present here. I welcome all the participants and paper presenters who have joined with us for this session. My heartfelt welcome to all the paper presenters who have come to our college in person. Welcome to the student volunteers. Reproductive rights are fundamental human rights that ensure individuals have the freedom to make informed choices regarding their reproductive health and family planning, which includes access to contraception, safe abortion services, maternal health care, and also right to decide to bear a child. In the context of global population dynamics, the legal framework surrounding reproductive rights play a crucial role in addressing population issues. Effective policies and laws are essential to protect individual rights while balancing social, economic, and environmental sustainability. This seminar aims to explore the legal frameworks that uphold reproductive rights, examine challenges in implementation, and assess their impact on population control and public health. We have received 100 papers from across the country on various aspects of the theme. Around 200 participants have joined the seminar. I hope there will be an exchange and sharing of knowledge in the today's seminar session. Once again, I welcome you all. Thank you.
Light is a symbol of knowledge, wisdom, and prosperity. To illuminate this event and to mark the beginning of our seminar, we will now proceed with the ceremonial lighting of the lamp. I request our esteemed dignitary, Dr. Bismi Gopalakrishnan, our respected principal, and the seminar committee to come forward for the lighting of the lamp. As the flame burns bright, may this seminar spark insightful conversations and pave the way for positive change. Thank you. It is now time for one of the most anticipated moments of the day, the keynote address. We are privileged to have with us Dr. Bismi Gopalakrishnan, a distinguished professor and head of School of Indian Legal Thought, Mahatma Gandhi University, Kottayam, an expert in the field. Dr. Gopalakrishnan has dedicated years to research and advocacy in reproductive rights, making invaluable contributions to legal and social reforms. Without further ado, I invite Dr. Bismi Gopalakrishnan to enlighten us with her words. Over to you, ma'am.
Honorable Professor Dr. Karanath sir, esteemed HOD of Law, HOD of Humanities, dear Annapurna ma'am, all my colleagues here at SDM Law College, students, researchers, and esteemed participants. I'm so happy that I could visit this esteemed institution, that too headed by Professor Dr. Karanath sir, who inspires every teacher. And the fact is that he's a role model for many of us. So thank you so much, sir, for giving me an opportunity to be here at this ICSI-sponsored national ceremony. Basically, the reproductive rights and legal framework addressing population issues is the theme of this particular national seminar. And to be very frank, we women, as stated by Supreme Court of India in 2022, have access to the full constellations of freedoms and entitlements, enabling us to decide freely on matters relating to our sexual and reproductive health. So, reproductive rights are definitely an essential for realization of all the human rights, that they encompass a spectrum of civil, political, economic and social rights, from right to health and life, the right to equality and non-discrimination and privacy, health information. All these are elements of reproductive rights, and definitely from freedom from torture and all forms of ill treatment. So this guarantee of these rights implies that women and girls must have access to comprehensive reproductive health care, and not only healthcare services but also for health information and services, so that both the women and the girls, they experience a very positive reproductive health outcomes. So the Constitution of India, as all of us are aware, recognizes many of these rights which are critical to enable gender justice and equality to women. For example, right to equality, non-discrimination, right to life, which is understood when we try to understand these through the feminist jurisprudence. It includes right to health, dignity, freedom from torture and ill-treatment and privacy. And the Constitution of India, again, as students of law, we understand that Article 51C is there. It categorically states that the government has a constitutional obligation to respect and international law and treaty obligations. So the canvas is more clear as far as the reproductive rights are concerned. So if we take the international perspective, that is the Convention on the Elimination of All Forms of Discrimination Against Women, the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social and Cultural Rights, the Convention on Rights of Child. So if you just read it with Article 51, the constitutional obligations, the canvas becomes very, very clear. So historically, if you try to trace out the reproductive rights and how it was being understood in India, we find that reproductive health laws was actually, it was glued with the population issues. So it actually failed to take a women's rights based approach. So instead, the policies and the legislations rather and the programs, it was being targeted on the demographic targets such as population control. So this approach, for quite a long time, it undermined the women's reproductive autonomy. And when the Parliament enacted the MTP Act of 1971, it was seemingly a liberal abortion legislation. But on historical analysis, we can easily understand that concerns about women's rights were hardly the drivers behind it. MTP was motivated by fears about population in India. We know the onslaughts of Sanjay Gandhi and the part of the host of measures including forcible sterilizations, targeting, to how to reduce the population in India, the population growth rate. So women's bodies, our bodies, were at least partially as a means. It was understood as a means to achieve the state's end. And what was the state's end? it was population control. So that is how it began. And the state was also alarmed at the number of women who died trying to access abortion from the backstreet providers. That was also a concern for the state. So the legislation of abortion in India was thus also motivated by the consensus about the presenting the basic health hazards that women were facing. Yet, here too, the rights were not the phrase that was initially being used. So, in the phase 1 of the reproductive rights, we find that it was exclusively population control. And the women was whether the woman was a competent decision maker, where the reproductive decisions entitled to be respected and enabled was not in the forefront in the first phase. Here, the state in the first phase, in the phase 1, the state was in the main focal point, and the state was draped in the aura of a benevolent person. The state was a benevolent person over there because we definitely had a welfare state. So the benevolence was there. So the attire of a benevolent ruler was there and stepping in at the right time to protect the woman from the unscrupulous medical practitioners. So that was the approach in the first phase. Now, slowly navigating from the first phase, the phase 1 to the phase 2, you find that slowly the right to reproductive rights came coming into limelight because there was a change, the shift in the international approach towards reproductive rights. The International Conference of Population Development, ICPD, was over. The people were becoming more aware of reproductive rights. The people across the world joined together in the march to protect women's rights in the reproductive sphere. So the rights language made ripples across in the domestic context also. So in 2008, the Human Rights Law Network, they began filing cases before the various high courts, seeking accountability for pregnancy-related death and injury resulting in groundbreaking judicial recognition of women's rights to survive pregnancy and childbirth. So in 2009, perhaps for the first time in the world, we have a judicial pronouncement taking hold of maternal mortality. That is, in 2009, Supreme Court issued a landmark judgment. You're aware of it. That is the Sujitra Srivastava's case. So that is the woman's right to make the reproductive choice is a dimension of a personal liberty that is mentioned in Article 21. So reproductive choices can be exercised to procreate as well as to abstain from procreation. And in this case, you can find, if you go through the judgment, you can find that Supreme Court relied heavily on privacy, dignity, integrity, and the court recognized that too. Again, if you just scan the other jurisdictions, it's for the first time that a disabled pregnant woman's reproductive right to resist being forced to abort her pregnancy was being brought into forefront. So after that very, very important decision in 2011, we have the Delhi High Court decision. It issued a landmark judgment in the case that is Lakshmi Mandal versus Deen Dayal and Harinagar Hospital and others, and Datum versus Maternity Home. So both these cases, it related to the denial of maternal health care to two women who are living below the poverty line. So the court stated in both these petitions, the main focus was on the inalienable survival rights that form a part of right to life. So right to life contains right to health, and right to health contains the basic right for access to medical treatment, essential medical treatment, and no woman, that too a pregnant woman, should not be denied a facility of medical treatment at any stage of pregnancy because of the fact that she belongs to the below poverty line, or she is socially backward. So you can find that from phase 1, where you give excessive focus to a population control, to phase 2, you're having clarity, we are becoming more and more clear, we are giving importance to the rights, and again the financial constraints is being taken into account by the judiciary, and the financial constraint must not be a restraint to fully realization of reproductive rights was being stated. So, women's right to make choice is a dimension of personal liberty under 21 that was categorically being stated, and both these cases, Srivastava's case and Lakshmi Mandal's case, form the bedrock of India's reproductive rights jurisprudence. Now, we have a phase 3 also. So, phase 3 where we find that it reflects the constitutional underpinnings of reproductive rights, their scope, the duty they impose on the state, the statutory interpretations and the like. So, right to the reproductive rights, right to reproductive rights. So, it is being expanded, it is being defined. So, what is autonomy? What do you mean by reproductive rights? What are the basic elements of reproductive rights? The duties and the obligations that is being attached to it. It is being getting clearer and clearer in phase 3. So, in 2016, through Devika Biswa's case, the Supreme Court moved beyond the right to health framework to recognize women's autonomy and gender equality as a core element of reproductive rights. So, the autonomy is becoming a focal point, and the Supreme Court established that the state policies and programs that introduce forced sterilization is an abuse of the fundamental rights of women, and Supreme Court made a significant step forward from the past jurisprudence which justified the violation of reproductive autonomy due to concerns about population growth. So, here in phase 3, the Supreme Court was very clear. It stated that Article 21 includes reproductive right, both as a part of right to health and right to personal liberty. And the right was defined. It stated that it is reproductive health information, access to health care facilities, access to health care services, and it also includes elements that help the woman to make free and responsible decisions about the reproductive behavior. So the freedoms to exercise reproductive rights and to make choices accordingly, especially relating to sterilization, must be on the basis of informed consent. So understand it's becoming, the vagueness is being jettisoned, and on the basis of informed consent and free from any form of coercion, we have to exercise the reproductive rights. And in 2016, the Bombay High Court, in its own motion was the state of Maharashtra, ruled to improve women prisoners' access to abortion, and strongly affirmed a woman's reproductive right to abortion as a fundamental aspect of this particular fundamental rights, and to live with dignity under Article 21. So, unwanted pregnancies, it was being taken hold of. It was being put under scanner by the court. It stated that unwanted pregnancies violate the woman's body integrity and aggravate the mental trauma of a woman, and it has hazards, it has negative impacts on mental health, and the unborn fetus. It was being stated by the judiciary, the unborn fetus is not an entity with human rights. Now currently we have been making changes in this particular statement. The unborn fetus is not an entity with human rights. the pregnancy, giving more importance to women, and the mental health and the physical health that she undergoes throughout the pregnancy, which till that time it was being taken as a normal one. But now the code stated that, look, it is not normal, don't take it as normal. Understand that an unwanted pregnancy creates problems within a woman's body, because biologically you are creating changes within the body, and the pregnancy takes place within the body of a woman, and it has profound effect on the health and mental and physical. Now, how a woman wants to deal with pregnancy must be a decision she alone can make. That's a very powerful statement. Now, it's the woman alone can take a decision, and the right to control their own body and fertility and motherhood choices should be left to the woman alone. Let us not lose sight, I'm just quoting. Let us not lose sight of the basic rights of women, the right to autonomy and to decide what to do with the body, including whether or not to get pregnant and stay pregnant, unquote. So the judgment is driven by a keen appreciation of body burden of a woman, of an unwanted pregnancy, a facet that is typically ignored and treated as routine, something all persons undergo. The consequence of an unwanted pregnancy cannot be underestimated, and the fetus relies on the female body for sustenance and nourishment and till it is born, and the biological process of woman's body has to be taken into account. And now the phase 4. Phase 4, from autonomy we have fused together equality and non-discrimination. So right to equality and right to non-discrimination is gradually engraved into the whole arena of reproductive rights. So reproductive rights, that is reproductive decisions, are intimate reflection of individual's autonomy and individual's identity. Now, what happens when right to equality is also being brought into the framework? So here, when a right to equality is brought into framework, you are giving importance to those disadvantaged, marginalized people who are denied reproductive rights on the basis of group identity. So here we find a shift in the approach of the Indian courts, which primarily gave importance to the rights of the matter of personal life and liberty. Now it is addressing it as a component of equality and non-discrimination. Now, Supreme Court in X versus NCT, it stated that reproduction is not just biological or physical, but it is political also. Because the decisions to get along with the pregnancy, these are political decisions, because it surrounds a lot of social structures. Women's role in the state is formally, we are in a society which has thick patriarchal norms, and the family is there, the society is there, and generally the childbearing, the society has its own perspective on all this. So, ensuring the successive generation, women is also seen as a vehicle for containing the successive generation. So, all these have a political tenor, political decision making, and such. Now, all these decisions, the Supreme Court decisions, especially in X versus NCT, we can find we have to appreciate the approach of Supreme Court towards the equality, how equality is introduced and how it assures a concrete dimension within the constitutional framework. Then the case, especially the Snehalata Singh's case, where the poor, the shabby and the inadequate public health care centers in the state of UP, it was being taken by the judiciary, and the judiciary was actually literally shocked to see this particular negligence. It stated that it is nothing but negligence, and it is a very negative approach, it's an extremely negligent approach, and the Supreme Court stated that, look, you are not sensitive to all these, the questions of reproductive rights you're not sensitive to the plight of the poor woman, and you are not sensitive and you're ignorant to your duty of granting or giving or sustaining the maternal services to the woman. So immediately, the judiciary stated, immediately you equip your state healthcare services with medicines, with vaccines, with so that the woman can make use of all this. And again, the judiciary also wants the state to enact policies, enact action plans, so that you can save the life of the woman. So the last phase, the fifth phase. Here we can find the current phase. You can find the removal of obstacles for an autonomous shaping of an individual identities. Here we can find that currently we are addressing how we can liberally interpret the MTP, how we can interpret the gestational period, whether the right to abortion it can be up to 20, 22 or 24 or even to 26. So the interpretation of gestational period is ongoing. So beyond the literal words of MTP, we are trying to evaluate MTP from a very liberal approach. Section 5 of MTP, it allows abortion outside the gestational period. So it uses its term save the life. So what do you mean by life? So it is whether it is the physical one or whether it includes the mental health aspects also. That is what currently we are trying to interpret. So the physical and mental health aspects was not being given importance in the earlier times. So life currently is being given a very wider interpretation. And so if we go through the current judicial jurisprudence, we can find that widening the grounds to 24, definitely we have made amendments to the MTP, but again if we just critically evaluate, we find that is, again it is give an upper hand to the medical professionals, but still we have the judiciary trying to interpret and say that this physical and mental health of a woman should be given importance, and that in the very latest stage we find that when a woman was in a living-in relation and then she was being abandoned and she wanted to terminate her pregnancy in the later stage after 24th year, the judiciary stood by her. That means we find that yes, the mental health aspects of women is being given importance from the perspective of the MTP Act. So beyond the literal interpretation, we are going to a very liberal interpretation. Now, one of the emerging concerns also, the emerging concerns in the next sessions, definitely you will, the speakers and the paper presenters definitely would address this particular issue, that is the importance of fetal life is also emerging. It's really emerging. Definitely we have a different approach, entirely different from the whatever that is being stated in Roe versus Wade or the American jurisprudence. We have a different approach, but fetal life was giving importance to fetal life, primary importance to fetal life was actually absent in all these phases. But now we find that slowly the fetal figure is growing importance in many judgments. So for some high court judgments, if you evaluate it, the fetus, it says it does not possess or it does not come within the arena of reproductive rights. Some say that, it just very cleverly avoids to answer this particular balance, and others, they give importance to the post-viability phase. So the potential child is a part. It's a human life, and it has to be determined. So that is an approach taken by several high courts. So our court, the Supreme Court, it stated that when it had there was a case it came before the Supreme Court as far as the abortion for on 20th week, it stated that it pronounced a statement, that is, the voice of the unheard fetus, it is there. So that particular statement was also being narrated, and in 2023, a petition, the Supreme Court stated that abortion, the Supreme Court was approached with a plea that, look, the MTP allows feticide. So the Supreme Court disallowed such a petition, and because it stated that if you allow abortion in the 26th week, that means MTP is allowing feticide. That was the main plea of that particular case, but Supreme Court disallowed it. Now, the fact is that at the fifth phase, it is very, very heartening to see that right to reproductive rights is being recognized with more and more clarity. But at the same time, we have to acknowledge that the fetus is no longer a shadow lurking in the background. It is rapidly evolving in form, and protecting the reproductive rights requires constitutional engagements, and talking about the fetal rights and the reproductive rights, we need a balance, a constitutional balance. Yes, in the coming years, Indian courts will be confronted with a progressive interpretation of the MTP Act, strengthening the law, and probably it has to address questions on what all reforms has to be made in the MTP law, and also surrogacy, and whatever the precedents, whatever the case laws has been articulated, whatever rights has been articulated in the judgments, and also through the policies, a strong call is there to defend the women's reproductive rights. And at this phase, we are very sure that women's rights is defined to include both reproductive health autonomy, including the health autonomy of marginalized populations. So looking forward for more deliberations like this, so that we can reach a stage of balancing between the reproductive rights and the fetal rights. Thank you so much for the patient listening. Thank you.
Thank you, ma'am. That was indeed inspiring and thought-provoking insight. Thank you for sharing your wisdom with us. It is believed that a leader's vision is the guiding force that shapes the course of any event and inspires those who follow. So with that thought, let us extend a warm welcome to our respected principal, Dr. Tarana, to deliver the presidential address.
Good morning to all. Om Shri Manjunataya Namaha. Most respected inaugurator of today's national seminar, Professor Dr. Bismi Gopalakrishnan, conveners of Seminar Committee of our college, Dr. Annapurna Sheikh, Coordinator of LLM Department, Ms. Kavya, the Student Coordinator of Seminar Committee, the members of Seminar Committee, distinguished faculty members, and my dear students. You just heard an intellectual discourse by Bismi Madam about the various aspects related to reproductive rights and its connection with the population issues. She is a very specialist in this particular field, because when one of my students, Ms. Suma, was doing the doctoral work under me, after submission of her thesis, she had to come for Viva. So I came to know that Dr. Bismi has evaluated her thesis, and the presentation of thesis took place, public Viva took place in Law University, Hubballi. And after the presentation, Bismi ma'am gave her version of the thesis. It was very amazing and intellectual output. At that time I was thinking, I came to know that Bismi madam has been specialized in the health law. So I wanted to call her for one or other occasion. But there was no occasion which is involving this particular subject as such. So one day Dr. Annapurna Sheikh came to me and said that, well, we would like to organize a national seminar on this particular topic. I was very happy. Immediately I recalled Dr. Bismi Gopalakrishnan and I told Dr. Annapurna Sheikh, she is a befitting person to come over here and take a session on that. And today it has been realized, virtually I am mesmerized with the thought-provoking speech which has been rendered by Dr. Bismi ma'am. So when Dr. Annapurna Sheikh another day approached me and said that we would like to have a national seminar on a topic called as reproductive rights as well as a population related issue, I was not able to understand what is the correlation between these subjects. Later I did little research. I thought that the wonderful topic has been taken up by seminar committee and that is also going to be proved because of the papers which have been received. Yesterday I was going through the various titles of papers, how many dimensions they have found out, how many issues are involved in this particular matter. It is quite amazing in nature. Of course, these topics are related to each other because our Montevideo Convention says that one of the requirements for the state identity, state recognition, is the presence of a population. When we speak about the population, there are two things which will come into our mind. One is the quantity of the population, another is the quality of the population. Both are having its own merits as well as demerits. If you are in a vast population, well, there is a labor force which is available. Well, the country will going to become very strong. And for various other avenues also, good population is always helpful. If you are in a meager population, the countries will go to struggle because they don't get workforce or don't get the human resource for the purpose of managing various avenues. So there need to be balanced approach related to population. And this population is directly connected with reproductive rights. So when we speak about these reproductive rights, the various rights will going to emerge in our mind. One, as Bismi repeatedly pointing out, is the right of the focal point of reproductive right is none other than woman. Second is that, well, the person who is yet to be born. Because as the law students, we always came to know about the fact that even the unborn person, since he can be born at any time, he is under the apparent expectation of the birth, he is also having the certain rights. The issue is that tomorrow, when he is going to be born, if he comes to know about the fact that his mother during the pregnancy wanted to terminate him, now if at all he is going to sue her, what would be the consequences? In a tort litigation sense that we have studied about it. Second is that one more right is that right of a father. Now the mother, the lady says that I would like to go for termination. Here the man says that even I have a right to get a child, the clashes will going to come into picture. Then fourth right is that issues related to the society at large. Now, see, society's notions with respect to religious notions are concerned, family compulsions are also concerned, it will have its own impact as far as the reproductive rights. All these things need to be managed. That is why today we are having a very right platform for discussion. And Bismi madam was telling that, well, people would organize seminars, conferences, but her understanding is that these things need to be materialized in the form of reforms or changes in the society. I hope that the things will go to, there will be very good deliberation in the later part of seminar presentation, etc. And when we go to come across definite legal principles which will emerge out of it, maybe we are going to refer the matters to the very appropriate authority because this program is collaborated with national level institutions. I think that deliberations, suggestions which are going to come out will be going to be communicated to that institution. I request all the participants to participate in a wholehearted manner. Wish you all the best for the seminar. Thank you, one and all.
Thank you, sir, for your words of wisdom and encouragement. Well, to express our gratitude and conclude this session on a thoughtful note, I want to call upon Ms. Sauparnika Hebbar, the Secretary of Seminar and Conference Club, to deliver the vote of thanks.
Good morning all. Praise is the fairest flower that blooms in the garden of gratitude. With that thought in mind, I would like to extend a heartfelt thank you to everyone who contributed to make this national seminar on reproductive rights and legal framework addressing population issues a success. First and foremost, a heartfelt thank you to our esteemed guests, Dr. Vishnui Gopalakrishnan and Dr. Kumunda Rao, who will be joining us for the latest session, who took time out of their busy schedules to share invaluable insights and experiences with us. I would like to take a moment to express my heartfelt gratitude to our esteemed guest, Dr. Shashikala Gupta ma'am, who will join us in the latest session for taking the time to join us today via online meeting. A sincere thank you to our respected principal, Dr. Tarnath sir, who always has supported and encouraged such enlightening programs. A big thank you to our moderators for their outstanding work in facilitating our national seminar. Your dedication and expertise made a significant impact on the success of our event. I would like to also extend my gratitude to our faculty convener, Dr. Annapurna Sheikh ma'am, and PG faculty convener, Ms. Kavya ma'am, who had worked tirelessly to make this event possible. I would like to extend my sincere gratitude to our esteemed lecturers, participants, LLM students, and all the students present here who have actively contributed to the success of our national seminar. A special thank you to our student volunteers, Master of Ceremonies, Prayer Group, Press and Media Committee, and at last my coordinators who have worked tirelessly behind the scenes to make this national seminar a success. Thank you all.
Thank you, Sauparnika. Now we move forward to the core part of this seminar, that is, the technical sessions. To lead us into the next part of the program, I request Ms. Anjana Kakad from 2nd LLM to take over and guide us through the technical session. Thank you all.
excellent. In March 2024, she received the Distinguished Woman Achiever Award from the Society of Indian Law Firm. She was featured amongst the illustrious 100 women personalities in the book The Phenomenal She, launched by the Indian National Bar Association. She is former member of Law Commission of India, National Judicial Academy and Bar Council of India, and was listed among 100 legal luminaries of India in 2016 by LexisNexis. Dr. Shashikala Gurupur has been conferred the annual Kitturu Rani Chennamma Award 2018 and 19 by the Government of Karnataka for her excellent achievement in the field of education and contribution to women empowerment. Dr. Gurupur has more than 106 publications and presented more than 335 invited lectures, workshops on gender literacy, human rights, media literacy, and seminars across India, Thailand, US, UK, Ireland, Germany, Australia, Canada, and UAE. She is a pioneer of EU legal studies in India. Currently, Madam is a member of CII National Committee on Legal Services and member of Sector Specific Group for Digital and Creative Economy in Government of India, Ministry of Education, Department of Higher Education, the Task Force on Governance of Higher Education by State Government Karnataka, legal member of IEC, also a distinguished visiting professor at the VBNUJS, a member of the Academic Council at MNLU, Aurangabad, resource person at NJA Bhopal, and PhD referee to many NLUs, JNU Delhi, Mumbai, and many state universities. She has been awarded with the most coveted professional achievement, Jean Monnet Chair Professor for EU Climate Justice Law Governance, Management and Policy, co-funded by the Erasmus Program of the European Union. Dr. Gurupur has undertaken various activities under the deliverables on JM Chair focusing upon law and policy on waste management and environmental sustainability. She is a team member of Global Evaluation and Accreditation, IANS USA. She has guided 15 PhD scholars, 120 plus master's thesis, and currently she is guiding 8 PhD scholars. She also leads the Spark project, 4 EU grants, NADFM training, and MCCIA committee. She has successfully led the Symbiosis Law School Pune to be among top 5 in India, achieving robust internationalization, quality academics, and research resulting in replication in Noida, Hyderabad, and Nagpur. With this brief introduction, I, on behalf of management, principal, staff, and students, would like to extend a hearty welcome to Dr. Shashikala Gurupur Madam. We welcome you, Madam, to our today's national seminar. I would also like to welcome Principal of our college, Dr. Taranath, to this session. A hearty welcome to you, sir. Last but not the least, I would like to extend a warm welcome to all the distinguished principals, academicians, research scholars, advocates, and students to the session. Welcome, one and all. It is now time to enrich our knowledge by hearing our today's resource person. Over to you, madam.
Good morning, Dr. Taranath, Professor Adya and Arya, and all the other colleagues, the other people who are present online and offline, who are the distinguished invitees. A very warm good morning to each and every one of you from Pune. It's a very commendable initiative that our law school has taken, because this is one area which needs to be seen very critically, particularly after two developments in India. One was 2021's amendment to the MTP Act, as well as 2024's decision from Supreme Court, from the then Chief Justice Dr. Chandrachud, in terms of distinguishing the cases between two abortions, and also once again reiterating the constitutional scheme of separation of power. Even though he has been obviously feminist in his approach, he took a little different view in one of the cases. And the critical insights which are coming after Dobbs case in the United States of America, whereby the Roe versus Wade liberal approach taken towards, revolutionary liberal approach taken towards women's right to choice vis-a-vis the fetus's right to life uh, got reversed in Dobbs' case, maybe because of the diffused approach in United States of America, as some of the scholars point out. Now, some of the critical writers point out that India's own approach in the light of Dobbs could be highlighted by others as a very liberalist approach, looking at a series of decisions, which I am going to highlight in my presentation. But then it is not driven by woman-centric approach. It is rather driven by population control or population related aggressive approach. Even when the maternity benefit even when the MTP act was passed in 1971, or when the Supreme Court reflected in the case of the famous air hostess case, that controlling population through controlling fertility of women. So this is exactly where my presentation is poised, and I would raise certain questions, and it would be very nice if the youngsters are going to uh, reflect on these questions. It's not moving for some reason. I have to move in the slide, I think. So you can see the slide there, right? Can you see the full presentation format? No, you can't. So let me go to the next slide. So my presentation, as you saw in the title slide, is looking at navigating population control and autonomy in terms of legal protection and challenges in reproductive rights. So recently I had the opportunity to talk about overview of reproductive rights in the context of reproductive justice with the GNLU. So that time my focus was more on how the idea of justice in terms of reproductive justice is not complete, and what are the gaps and how do we make it complete. How reproductive justice concept is a hybrid between social justice and reproductive rights. So logically we'll have to go in terms of understanding reproductive rights and how these reproductive rights are not complete in terms of the loopholes they leave when one looks at reproductive justice. So I would like to first journey you through this concept of reproductive rights. Now, what are reproductive rights? When we look at reproductive rights, it is connected to reproductive health. And health here is not just physical health, it is mental health as well. And what is considered very natural for the female body in terms of the changes in the body to be ready for reproduction, and undergoing that reproductive process and post-reproduction recovery, and the way the body changes after a certain number of years post-reproduction, whether all these are taken into consideration when the policies are made or when the law is looking at it. Most of the law is looking at the framework of marriage, children, and reproduction within the structure of the marriage. I'm not here to say whether it is right or wrong. I am here to say that female body and its awareness and the safety of that body and the changes that that body undergoes and the vulnerability of that body in a very difficult socioeconomic and cultural condition where the body is perceived as a means of pleasure, and it can be overpowered unless the women are trained in defending this body. So there could be the body undergoing that reproductive change unwillingly also, outside the frame of marriage also. This is exactly where MTP Act in 1971 did take care of that. But the whole aim of MTP Act seems to be focused on reproduction in the context of family, where more and more population control dimension seems to be in the focus than the critical angle which you have focused in the conference, which is about autonomy, which is about reproductive choice, which is about making that choice by respecting that body. So that is what is to be seen in terms of reproductive health, that reproductive health beyond the physical, beyond the socio-cultural, beyond the marriage structure, and within the idea of health as physical and mental health, social health also. I will tell you why. Then comes the question of wellness and well-being Well-being is bigger than wellness, and that well-being has got certain conditions, and it is about quality of life. And then human rights, in terms of human rights framework for women, which is drawn in CEDAW, Convention on Elimination of All Forms of Discrimination Against Women, and subsequent conferences like Beijing Conference, etc., which came to implement these rights, looking at the increasing violation of women's rights, increasing discrimination, and also violence against women. Then comes the idea of looking at this whole debate from the feminist legal theory point of view. Feminist legal theory talks about looking at the reality from women's eyes, and that biology is not the destiny, and that in looking at women's reality through women's eyes requires to take their authentic experience as what we call as narratives. They have to state these experiences, and while stating those experiences, we come to know many other qualitative dimensions of their experience, which do not figure in the quantitative study or in the legislative language. So that is what feminist theory argues about, that justice is not objective. It seems like male objective dimension, which needs to be seen and being inclusive to include the female experiences. Second point is reproductive justice. What is reproductive justice? As I told you, it's a hybrid between social justice and reproductive rights, which includes a safe and healthy environment for both women and children who are in the vulnerable group, cultural references, and more effort in terms of people who are on the fringes, such as migrants and refugees, disadvantaged women, because they are disadvantaged in multiple ways because of the caste, because of the religion, and poverty, which gives them other disadvantages. And this disadvantage, what one of the great theorists calls as web of poverty, because poverty is not just violating one economic right, it violates many other privileges. Web of poverty is the theory which shows. And there was also our own Ram Manohar Lohia, who talked about feminization of poverty. Poverty hits the woman very hard in many ways. We know of the cases of women becoming victims of rapes when they go out to nature call, because the poverty doesn't permit them to build their own toilets. Today there are other arguments that they have mobiles but they don't have toilets, but basically women's sanitation and health is very, very important. See, something as basic as whether our own educational institutions accommodate these nuances of women, because initially in law schools there were no full-time women members, or in the courts also very few women. I mean, first lawyer was allowed in way back in 1923 only in the Indian experience. In the turn of the century, 1898, 1923, 3 women were allowed in 3 parts of India. So the whole structure, that's what Chandrachud also argued, that district courts and high courts also need to accommodate women from the reproductive health point of view. It's very important for adolescent girls to have a very hygienic toilet and environment and napkin dispenser. And it's very important for adult women to have their menstruation related things. And when they're pregnant, they tend to go to the toilet very often. And how many organizations have proper maternity benefit? If you look at all that, a woman's body is not reproducing for her own fancy. It is a social duty, as Anne Oakley said, that she is fulfilling. It is the progeny that she is carrying forward. It is the human resource that she is producing for the nation, or she is sustaining for the nation. So whether all these things are taken into consideration, and also man's role in terms of being a parent and supplementary role, and in encouraging and supporting the woman to have these basic entitlements being complementary to her exercise of rights. So it's a very inclusive process in reproductive justice that is seen. And then human rights of these adolescent girls. I will give you examples. We have done studies on this, and woman-centered rights-based focus is in the core of reproductive justice. Now, reproductive health research, if you see from the legal point of view, it's closely bound up with feminist jurisprudence, reproductive rights, quality of life, and SDGs, among other things. So if you look at the reproductive life cycle of a woman, it begins with her being a woman, being born as a woman, and then going through the menarche, where her body becomes ready for reproduction, what we call as achieving that menstruation or periods. And then she will go through this whole process of reproduction. And after that, during the process also, she may have complications. Sometimes they develop mental illness like hysteria due to hormone imbalance or lack of care. All of us know in Kannada the famous Sharapanjara movie, and many other writings. And I think that Ashok Pai from Shimoga has written extensively on this. So it's not just about the physical neural limitation, it is also about the environmental factors and lack of care by in-laws or own family. And that is also sometimes due to ignorance or insensitivity towards that body which is going through this process. So once it is all through, then they may face very different problems during menopause, especially women who are in the career line of 40 plus. Between 45 to 55 they go through this stage, and they say that during that time the whole brain behaves as if it is a brain of a dementia patient. So unless women are given this understanding of menopausal management, it's very difficult. How much of focus is there? Wellness is always focused along with reproduction. And then comes the question of some of the climatic factors which result, like nowadays girls maturing very early, so they are still innocent and they are undergoing this change, therefore becoming vulnerable to many other issues, and their own education and developmental phases going for a toss. And are the schools equipped to go through this? Whether the schools are doing it? Because these physical changes, earlier I remember my own mother's generation, women were not, you look at those women who were in school before 1960, most of those women left school the minute they attained menarche. The reason is simple, that their parents were very scared of them becoming victims. Second is a secrecy, mainly the hiding of this whole bleeding process. So this is one thing that all of us ignore, because this is a matter of stigma. And what Justice Chandra remember, in our family, aunts used to say the minute they matured, there was a very big ceremony whereby all the relatives were invited and it was fed. She was just an object sitting there watching all of this, and then also going through these changes, because a lot of physical change would have happened. I have not seen literature focusing on this. I have not seen much of science study around this. So this is exactly where our research needs to be more and more pointed, because today India is having more than 55% of young people. So in that 50% means about 25% of India is young people who are in adolescence to 30 age, the productive age group and reproductive age group. Now, improper handling of reproductive care and reproductive rights could result in their shunting of personality, deprivation from the production process in employment, or any kind of gainful life stream. So this climatic factor affects them. And then imagine, we used to live in flood prone area, so if at all you underwent that physical change during that period and all around you're surrounded by flood, uh, the flood management system is not factoring these issues. Somehow these women managed. I was talking to an NGO, which was because we had an ICSSR project where we talked about disaster and human trafficking. And in those tents where the refugees live, whether they are climatic refugees during cyclone or they are refugees after communal riots, what kind of misery women go through. I mean, just imagine recently over this Palestinian conflict, what would have happened to the women who were, I mean, we had stories of pregnant women not being able to walk, man being shot dead. So these are the issues where peace needs to be there and violence needs to be avoided at any cost if you're caring for reproductive rights, or factor in the care for such vulnerable women who are reproductive. But when you are so ridden with the hatred, you don't care about that progeny who is contained by this woman's womb. So these are the negative side, or these are the greatest challenges to reproductive rights and reproductive justice. And then I told you, female and child mortality, maternal and child mortality happens because of many reasons. I'll give you stories, then you will know. Violence during pregnancy, menopause, indifference, neuropsycho ortho nuances means once you attain menopause, as I told you, there will be brain process, there will be psychological loneliness which they feel, because that exactly coincides with their children leaving the home, and then for higher studies or for other reasons, employment and others. Because in India we plan this in at a time when exactly the child is able to earn when you are to retire. So all these calculations of middle class. And then the ortho problems these women go through, they have one fall and they break the bone. And the proper medical care and awareness, and creating that kind of awareness about menopausal women is something that is very much required, which the policy doesn't focus on. I'll show you the policy wording. So we did a study for the master's thesis, where a girl from Orissa, Sushmita Rath, we published it in Scopus Journal. It was about menstrual stereotypes, because we were inspired, 2020 Shabarimala judgment, where Justice Chandrachud talked about untouchability. So we wanted to explore in how many communities this untouchable treatment is still there. Some people may argue that it is for the rest of the woman, it is for her physical recouping. We agree, but do it with her awareness. We have worst situation in Kadugullas, where the girls are kept outside the village and she may become a victim to predator. Imagine a 14-15-year-old girl being put in a hut which is far away from the village. Many of them have become victims of sexual offenses also. There is no documentation because they're poor and they're nomadic and they have this rigid approach. So now social welfare department in Karnataka has been very active. So we need to really do. So this girl did it in the Orissa tribal context, and she was able to bring out good sample size. And finally, she argued that any such discrimination should be punished like how we do untouchability practices. Under civil rights, you add this untouchability akin practices, which may be gender based or any other, even disability related practices. All these should be punished under SCST, current Civil Rights Act. So that is the recommendation we give. So when we look at women's human rights from the point of view of reproductive rights, it is about choice, it is about autonomy, it is about awareness. So I'm sure you would have understood by now how reproductive rights and reproductive justice and human rights are interlinked. When I go to the specific cases, it will be more clear. I gave you a study. We had another study which was conducted between Bangladesh, Nepal, Pakistan, and India, about Sri Lanka as well, based on Google survey, because it was height of COVID period. So the girl did the study on human rights framework on reproductive rights of adolescents. Once again, the rituals of period and exclusion, because of that deprivation in education and grades going down, iron going down because of their memory power going down, then saying that, oh, she's useless, she's better to be getting married and producing children, this kind of attitude. So imagine a country needs both men and women to be in the production process, and then leaving it at their choice or taking a break. We have studies which show even in the legal profession, Rainbow group has Rainbow, the research team has done a wonderful study. I don't know how many of you law students or lawyers have come across. There they talk about how in the interviews they will ask, so what is your family like? Because they want to know if she is going to get married, or is she already married, where is her husband. Means they don't want to invest if she is going to go away with the husband if he is in military or if he is abroad. Second is, once she gets a baby, of course, Maternity Benefit Act talks about now after Smriti Irani came, it has extended to 6 months, etc. But the guilt that the woman has, recently somebody was talking about that maternity guilt. Aside from that, her own physical and mental makeup, because it is such an intimate relationship, mother and child relationship, and the non-engagement of fathers, and then the parents not being able to support. It's not their duty, it's your duty when you have decided to reproduce. So what happens is, and the house help, if you are getting whatever you are earning as a woman, I mean, wages are also not well negotiated by women, and once you go through this, the kind of wages that you are getting also might be less, because when the child is ill, you take leave, not the husband. So all these evidences they brought about, and they argued that there should be a proper hand holding for such women by the law officers or by the organizations. We don't seem to think like that. We seem to think that why will I interfere with her motherhood? It is better that this woman is with her child, as if paternalistic way, as if she can't decide and you decide for her. So some of these things are regarding the production process and national capital and reproductive rights being blind to that, and reproductive rights to be read into this context, which will give you a more fair and just approach. So socioeconomic well-being of women and girls based on full achievement and protection of women's human rights, not just civil and political rights like voting and participation, freedom, etc. They are necessary. Along with that, socioeconomic and cultural rights. So intent to produce, availability of contraception, the choice of their satisfaction, and then freedom to decide the structure of reproductive choice and development, with right to control fertility as a woman. So these are very important. Without that, her role in production process and participation in national development cannot be proper and ensured. So this is what WHO said, World Health Organization, which is globally a kind of gold standard. So it is not for reproductive justice concept is a very critical concept, because reproductive rights came from that rights based approach, which was always by jurisprudential jurists, and which are dominated by the white and male, or white women. So the women of color were absent. So the whole reproductive justice movement started with the black women being in the forefront, because uh, black women mostly came from socially, economically deprived background, poverty. They were migrants and they were excluded, they were discriminated. So, and they were also the HIV affected people. So reproductive rights and reproductive justice, they started rethinking, and they said that it should be holistic, inclusive, and not individual women choosing the reproductive right, but state facilitating this right, courts being sensitive to this right, policies being sensitive, and having that differentiated attention, especially in case of the poor and the racially poor, and migrants, etc. So one of the challenges to reproductive rights, and one challenge I told you already, which WHO has tried to spell out through the Black movement, is the challenge of reproductive right being individualistic, whereas the need to go to justice dimension of reproductive rights wants to look at it as a collective and inclusive reproductive rights. Second is challenges of bias, unawareness, and customs. As I told you already, rituals of adolescent. And one challenge that India has is child marriage, where the woman cannot choose, and she is not a woman yet. She is still in the protection of the household, and she blindly trusts what Ravi Belagare's mother, Belagare Janakamma, long ago wrote in one of the poems, that what she says is in Kannada. If some of you don't understand Kannada, I'll have to translate that. She uses the word ವಾಸನಾ ಬಲದಿಂದ ಬೆಳೆದ ಪಾಶವನಂಬಿ ಒಳಗೆ ನುಗ್ಗುವುದೊಮ್ಮೆ ಎಳೆಗರುವಿನಂತೆ. Means how the woman, or for her it was Elegaru, because Belagare Janakama must have written, imagine Ravi Belagare himself, when he expired, he was in the 60s. So his mother would have written it some 70 years ago. So what she talks about is that you are like that tender calf who trusts the roots or the rope which was tied around the neck as you were growing up, and you trust that roots or the rope, and then you just barge into the whole system like that tender calf. So it it's not exaggeration. I mean, in child marriage, that's what exactly happens. But I have seen the very dangerous side of child marriage. When I was doing the report for Dr. Jayamala on sex workers in Karnataka and their rights, and we made the recommendation, humongous recommendation based on 10,000 women surveys and 3,000 narratives on reforms in terms of skilling them, in terms of providing them insurance support, in terms of giving them and their children the support. We have series of cases in the Supreme Court, Gauri Jain case, Buddhadev Karmaskar case, where the case was for murder, but Justice Karju ended up with a lot of recommendation, because of which the Karnataka government took in 2016, Siddaramaya's government at that time, very seriously this issue. As a result, some 500 crores were earmarked for that. So one of the things we saw was 45% of the people we interviewed were trafficked as children. And you will be surprised to know that out of that, about 30% came from child marriage. And another few percentages came from stealth, relatives only pushing them into that. Sometimes parents also, no feeling, just to sell this girl. Sometimes it was in the name of religion, where they committed her to Yellama goddess, and the one who came in the form of Uditumbisu, means giving her all those gifts, was a contractor from Mumbai. So this was happening in that belt, which was 4 districts bordering Maharashtra. So the NGOs started working there. They started focusing on adolescents. So it's very important to look at adolescent health and adolescent rights. That's why we developed a framework of human rights dealing with the adolescents. So wherever this Kishori program went, there the girls refused to go through the ritual, Uditumbisu ritual, because Uditumbisu means next is you are married to the Lord, and then there is no Lord as such, and then there is that all the priests and landlords and other village power structures, committing aggression and also transporting them to the red light area of Mumbai. So this was a consistent thing which was broken. And then the Jogitis were earlier repositories of culture and knowledge. Because of the British and other barrack system which came by invaders, Mughals and British, the whole Jogiti tradition was converted into sex trade. And they were used or forced, not voluntarily, otherwise they were voluntarily repositories of dance, art, music. So how a beautiful temple tradition got, completely perverted. So we saw that these customs of child marriage is one of the biggest challenge. And now I'm very happy journalists are more sensitive now. They are writing about the girl crying, and the social media and reels going in the social media, making the officers to be alert, police to be alert, and removing the girl from the clutches of such marriage and getting the people booked under POCSO. After POCSO has come, Child Marriage Act has developed strong teeth. That's what we are seeing. And child marriage is blatant violation of reproductive right. Because the child is powerless, and the child is either mentally manipulated or physically forced to go through this child marriage. And the once it was less, maybe because we thought it was less as the news and social media didn't penetrate. Today everybody holding a handset is able to retort against this, and there is a lot of effective enforcement. So one story I would like to tell about lack of reproductive health knowledge resulting in reproductive injustice and deprivation of reproductive right is the story of this doctor in one of the villages near Mangalore, where the doctor was practicing, and then he had to he got a call, and he goes to this house after taking an auto, then taking a boat to this poor Muslim lady's house. Man was not in the house, and little children, and this woman was undergoing delivery pain. Local nurse had come and delivered one child. Still she was crying out of pain. Then the doctor didn't have, he was trained, he was MBBS doctor, he was trained in the hospital. He didn't have any kind of equipment or emergency life resuscitation kit or anything, but he put the faith on God, and he touched the tummy. He came to know that there was another child. It was a twin pregnancy. So lack of basic awareness or facility in the villages for scanning, and then for, maternal health is not just about going for the time of delivery. There are many dangers to the mother. This is the reason why maternal mortality is very high in India, because we see it as natural process. It's not like every body is not the same. In olden days, in Middle East, I came to know about stories before they struck upon oil. Women used to give birth and then they were filled with sand and they were left there. Means till our modern doctors went there and educated them, and women started coming to them, and then they started looking after their bodies. So this shows that women's own awareness and also community awareness, family awareness is very important. Second is this abortion pill. Abortion pill has got lot of side effects and women may bleed to death. Young girls are taking it across the counter and then they are suffering lot of hormonal changes and problems. Injectable contraceptives also, Vandana Shiva writes about it. Injectable contraceptives have been introduced only in our countries, Asian and southern globe, because she says the assumption is as if these women are illiterate, they can't remember to take the morning after pill or contraceptive pill. So injectable contraceptives have highest health risk. So that is given without, we have this idea of prior informed consent, right? So for these women, are you giving that information? It is not something normal. So that needs to be properly done. Whether these rights are ethical and legal dimensions are taken care is another story. And then delays in treatment when a woman undergoes menopausal bleeding or she undergoes other pregnancy related problems. She is the one who delays. She thinks that, oh, today my child has exam and I have to spend my money for that important thing. Let me see, it will become all right. No, anything beyond 24 hours is dangerous. Birthing plan is a reproductive choice. We all, in the West, it is very important that you make your choice on how you want to give birth. So mentally you are readied. Here it is, I think there is a women's support system here. Although they don't talk, they support each other and they do. So it is taken for granted, but we need to be more medically ready. Cultural barriers also about talking, and marriageableness is one important thing that girls are focusing on. This is what happened. There is a beautiful study taken from a village by an international legal scholar who talked about how in the hospitals when the girls came, the elder member of the joint family will come and he will say she should look nice, and then the doctor would say no, she has got certain cyst in the ovary that needs to be handled. Then the person would say no, let her get married, then it is her husband's responsibility, she anyway doesn't belong to our family. So marriageableness and marriage related dimensions are really making girls' rights to be ignored, and treatment decisions are not taken by women. There was one case which I came upon by IIM study in Chennai, where the young woman was not allowed to see the doctor because the mother-in-law said that today's nakshatra is not good, Rashi is not good. And then she goes and then she delivers the baby, and the mother-in-law said that the baby, every baby is not the same, every woman is not the same. So there was really problem in her naturally nursing the child. The mother-in-law said she is not good as a daughter-in-law. And then that affected the woman, and finally after birth complications she died. So, and also male child preference. When the child is not male, the man threatens that maybe your third child will be female, fourth will be female. If the fourth is not there, after the fourth also, if I don't get, then I will change the wife. Scientifically speaking, it is man's XY chromosome which decides whether it should contribute X or Y. But they remarry. So male child preference is another issue. So we need to be very clear about it. But interestingly, in our India, West Coast, Kerala, and especially in Mangalore, also in Shetty community, we have had instances of women going for niyoga when she didn't get a female child. So this is the other side. But then the openness in customs and the power depends on who has the legal power to decide on wealth and property. So we had instances, but we don't talk much about it. But then these have been spoken about. So conflict with the employment is another dimension. The employer not giving leave if she's suffering there, and employer not give. This doesn't happen in colleges and all. We are all aware people, but it happens in some private employment, even in government employment. There is no sensitivity. If it is a female boss, it is different. The female boss would say you didn't take care of yourself. So affording the health service also We have in campus doctor available, mental health, which is related to that, reversal of surgery. Sometimes, woman goes through almost surgery, almost normal delivery, and suddenly she has to go through this one. Sometimes reversal of surgery because something was left in the tummy, many negligence cases and heavy bleeding. So these are the stories which show you why feminist legal theory is important, which looks at motherhood as a choice, adolescent rights in order to facilitate the development of that girl as actualizing her self-actualization, access to healthcare differentials which are there about male and female health, and vulnerability because of multiple factors, and what Vandana Shiva calls femicide. uh, you know, death of women because of these issues, and also injectable this one. And she calls it as genocides. Other side is femicide because these contraceptives, injectable contraceptives, are developed exclusively for the third world countries whose generation they don't want too much, and indifferent to their health. Awareness in terms of literacy, intervention, and capacity building wherever these issues happen. We have seen this harassment in domestic violence, workplace harassment also. If someone makes comment about such problems when woman is undergoing this problem, gendered comment, it can come in the workplace harassment, and domestic violence and other human rights dimensions. And child marriage, of course, independent thought case Justice Lokur spoke about in 2017, that a child marriage is strictly violation of human rights, especially child rights convention. And a man, even in customarily organized marriage, a man commits the offense under POCSO. He had the daredevil attitude to say. Therefore, age of consent is for marriage is 16 as of now, which is again a misnomer, because whether marriage or anything, consensual age should be common. Second is, in these cases, it's not consensual sexual act. It is going to be dubbed as marital rape. So marital rape was mentioned in this judgment, which is a very strong approach. So this can become a death blow to child marriages if we are strictly implementing. I mean, now in prevention of child marriage it is implemented, but once the marriage is over, and as soon as marriage is over, women are pregnant, then it becomes difficult because the child will be having the illegitimate this one. And in India, one judge was telling me, when I was in the commission and I was trying to assert on age of consent, he said that if we are very rigid, 54% of Indian population is 54% of marriages in India are child marriages. So imagine so much of progeny will become, will declare in that voidable or void marriage. The children will become illegitimate. It may affect their inheritance rights, among other things. So this is the kind of conundrum that legal system is facing, because they didn't care about the reproductive rights of women. Now, I was just going through the policy communique of Government of India as recent as 10th December 2024. If you look at this population policy of Ministry of Health and Welfare, I have very interesting observations. One is alignment with National Population Policy 2000 and National Health Policy 2017. Total fertility ratio was 2.1, but government claims on this website that they have achieved 2 per couple. So question is whether these couple are properly choosing this. The woman has chosen, is this population control compatible with human rights? This is first point I'm asking. Second, expanded contraceptive choices, is it in consonance or resounding with reproductive justice? Then there is Parivar Vikas targeting Northeast states, which is awareness, which is part of the reproductive right framework. Compensation scheme for sterilization acceptance, because poverty is tackled here. Post-pro pregnancy contraceptives, which is also supplied at home by ASHA workers. This is an interesting dimension. And men choosing in terms of population control, not just women regulating their reproduction, contraceptive not targeted only at women. It's very interesting that HIV control, contraceptives were condoms were given to women to be supplied to the clients, as if woman is the agent to supply, and she takes the decision for his sexual choices. I mean, it's a kind of servant model, very servile model, which was seen there also. So vasectomy awareness is a good step, but men have that fear that their productivity in terms of physical power will come down. So that needs to be seen also medically. This fear, it is not just in India. I've seen it in Ireland also. So logistics and information system about the whole project and schemes is one good step, because that helps to formulate more policy, see the loopholes, which is very much required. So my contention is this whole framework is in the form of piecemeal, and there are many blind spots if one is viewing it from the uh, um, if one is viewing it from the reproductive rights point. 1 minute, I'm in a lecture, my lord. After 20 minutes, okay. Ah, I'm going to office on the way. So I hope I made it very clear to you. This is the reading of the policy. Whether this kind of piecemeal approach and these blind spots from the reproductive rights point of view, or reproductive justice point of view, is glaring, especially piecemeal as I go further. So if you look at the right to privacy judgment, Puttaswamy judgment, it's very clear that reproductive aspects of surrogacy and abortion need to take into consideration the privacy of women and privacy of family as well, and privacy of the offspring. And then in reproductive rights as human rights, if one is looking at whatever we discussed in terms of the number of children one has to have, the couple and individuals must decide, spacing and timing of children, and the information related to that, and the right to achieve highest standard of sexual and reproductive health. Does our policy say that highest standard to achieve reproductive health? It is only talking about piecemeal way of addressing the population control dimension, as if that body has to be selectively treated. Right to make decision concerning reproduction free of discrimination, coercion and violence, as expressed in human rights document. What happened in India during emergency? Some of the bastis in Delhi were forced to undergo it was called nasbandi, which means blocking a nerve, which was majorly vasectomy. So it's not at all good in modern civilized society. So it should not be there. And discrimination also, that too much focus on tubectomy means women's reproduction, women's birth control, and not men's, or equal, or guarantee by other family members that they'll be looked after. I once was traveling by bus. I was teaching in SDM at that time. I saw a woman who was young by face and body, but she was not able to get up. When she was walking in a wobbly way. And I got talking to her. She looked very poor, but she looked very young. So she was barely 28 and she had two children, and she underwent her whole operation in a camp, medical camp. So some of the trainee students must have treated her. So things really went wrong. And I was advising her, why don't you see a lawyer or go to the district court and file a complaint, and then you should be entitled to compensation and all that. She was telling me, I'll go to the government hospital, take some pill and this and that. It was interestingly a private medical college which held this medical camp. So, utmost concern of women's sexual and reproductive health with the highest standard is the United Nations standard, gold standard, and the right to terminate the pregnancy for a specified reason. Please understand, termination of pregnancy is not a licentious right that is given by the law. It is given for specified reason. The criticism there is that it's always that a man has to consent. What if she's a rape victim? You don't know. So if she is a younger victim, then her parents will consent. In case of rape victim, it is allowed, but doctor also can take the decision, but the doctor has to inform. This pressure on doctor to inform is also being criticized. So other than that, it is in the general interest and the child's interest. But if she has crossed pregnancy stage, because sometimes rape cases, treatment is also not correct, the way there are no standards on that also. We need to improve on so many fronts. So suppose in a country like Ireland, they don't allow abortion. In India, abortion is allowed. But then in case of rape victims, there are many cases you would have seen in the Supreme Court where till the 25th week, 30th week, it's not allowed. There are cases where The ward of the girl wanted her not to keep the fetus, and in the process of mentioning this court and obtaining the order, the girl attains 18 years and she wants to keep. And the court said that you have to respect her choice because now she's the mother. So, international law is the foundation of the reproductive rights. There is no single exhaustive human rights instrument which talks about fully about reproductive rights. That is the limitation. And then all the points that I told you is under that. So the enumeration of the reproductive right happened in Beijing Platform of Action, Vienna Declaration. There are 12 human rights. One is right to life, right to liberty and security, means safe abortions, choice of abortion, or choice of contraceptives also, right to health, including sexual and reproductive health, right to decide number and spacing of children. This is very important. Right to consent to marriage and equality in marriage, and then right to privacy, right to non-discrimination and equality free from practices which are harming women. We have female genital surgery in Africa, child marriage in some cultures, right not to be subjected to torture or cruel or inhuman or degrading treatment or punishment. We have had in the past in the Indian Penal Code also, if you open the Bare Act, these cases are given where the girls have been, women have been forced by in-laws or the husband because the dowry not to keep the progeny, means forced to abortion, and the doctors who are colluding in that, the hospitals, all of them are criminally liable. A right to be free from sexual and gender-based violence, very very important. It is connected to reproductive health because violence can have impact whether you are already a mother or you are going to be a mother. Right to access sexual and reproductive health education, access to information, very important. European case, Stephen Grogan case in 1995 talked about this because Ireland prohibited abortion. So they arrested Stephen Grogan. He went against it, and European Court of Justice said that what he is providing is only information. He is not violating your law. Right to information is part of the human rights in terms of civil and political rights. So Stephen Grogan's information centers were continued in functioning. So he was providing information on health, on nutrition, on where abortion is available outside of Ireland, especially England. Right to enjoy benefits of scientific progress. So they should have. Uh, why this has come? Because in some religious faiths you are not allowed contraceptive. Christianity didn't allow for very long. In some religious faith you are not allowed to have blood transfusion, among other things. So this human right instrument clearly says that when there is a conflict between a neutral right like health, which is part of sacrosanct right to life, then custom should take a backseat. Human rights take a precedence. So there are diversity of rights. CEDAW also talks about it. Child Right Convention talks about it. International covenants talk about it. Disability Convention also talks about it on their reproductive health. In India, if you look at it, in case of disabled children, the case came up before the court that in an orphanage, a mentally less able girl became pregnant, and then she wanted to play with the child. She wanted to keep the child. So the court said that she may be physically disabled, but emotionally she is not disabled if she has made a choice. She is the mother. Her reproductive choice should be respected. So it's a very revolutionary judgment. So this is a snapshot of different international conventions. And then I already talked about how adolescent exclusion by keeping them outside the house, outside the village happens, which affects their affects them. So right to highest attainable standard in health, and right to choose the family, and women's choices and women's evolution, their entitlement to other human rights need to be protected and considered when you're talking about custom related practices. So the gender neutral dimension here is men and reproductive right interface, where they talk about men's general health, the knowledge and attitudes regarding family size, spacing between children, and then gender preference, whether they should have only male child. Many men say, I would love to have a boy who will have a beer with me, or who will play cricket with me, who will hold hand and go in the ground. So these dreams are very good, but then you have to respect that your spouse also is not a machine, and these are nature's processes, and then you have to wait. Or you can't force her to have 4 children, believing that your grandfather had 4 female children and after that there was a male child kind of logic. So these are all not very in consonance with civilization. I've seen these uncivilized behaviors in my surroundings, so I'm talking about it. Burden for preventing the disease in HIV case. We had one village in Karkala full of HIV because every family had a member in Bombay. I'm talking about mid 90s. So this kind of concern and exercising proper contraception in order not to spread the disease is also a very important human right. Now, there is one interesting dimension that we have to see. I have captured those cases. Written consent of the guardian is necessary if it is minor. Currently, the legislation is doctor centric. Consent of the husband is required, and then they wait till the late, and there are unholy collusions, as I gave you the example. There is no termination without the consent of the woman in normal cases of abortion. However, in complicated cases, courts consent is necessary. We had mentally ill children where they said state can consent, but subsequently this approach was changed, taking the emotional side of the science information that the mother has to consent. One interesting case we had is where the woman terminated pregnancy without the consent of her husband, the Mangala Dogra case, where it was allowed because woman, it was a pro-choice judgment. However, husband may take this as cruelty and file a ground for divorce. This happened in Samar Ghosh. Before that, also Usha case in the 90s, many cases in Delhi. So, what about convicts and under trials? Do they need jail authorities' permission for abortion? Answer is no. If they intend to undergo abortion, if they're pregnant before coming to the prison or pregnant after coming to the prison, then they have the choice to abort the child. Indicate that a mildly retarded woman can continue pregnancy resulting from rape. This is a very revolutionary decision. Suchita Srivastava decision by the Supreme Court in 2009 is very important decision. So one red line that runs through all the cases is when it comes to the goes a case to case basis approach. Just give me 1 minute. There is somebody at the door. By the in 2009 is very important decision. Red line that runs through all the cases. When it comes to goes case to case basis. Just give me 1 minute. Okay, let's continue this. You are seeing the slide. So the Suchita Srivastava case is a big turning point in this matter. And then we had the contested terrain of abortion. Now, working woman or homemaker or prisoner woman owns her body and has rights over it. And they also talked about maternal deaths to be preventable. That is why the policy focus now is a lot. Now, one of the issues that has come is the unsafe abortion. An untrained doctor doing medical termination of pregnancy. We had a Jacob George case where they said that criminal prosecution can be had in such cases. I have picked those unique cases, and you have the PPT. You can go through within the limits of the time. So now the question is, whose right is the reproductive right? Is it only the mother's right? Is it the fetus's right? Usually the conflict globally is between a mother's right and fetus's right, whereas in India the state engages. So whether Indian approach in the light of America's Dobbs case, is it liberal approach or is it aggressive population control policy? So this is the debate. I gave you the population policy and I showed you in the light of series of decisions of the Supreme Court and also recent amendment in the Medical Termination of Pregnancy Act, the time limit being increased to 24 weeks in consonance with series of Supreme Court decisions on case-to-case basis. So one case was one X case. Usually we call these cases as X cases because we don't want to name. 2016 decision where fetal abnormality posing risk to the physical and mental health of the woman, she may undergo termination. So Supreme Court permitted because the fetal abnormality, because fetus's right of survival and chance of survival alongside the mother's own survival because of the quality of life that may get affected because of fetal health issues. Now comes the question, gestation limit. When you opt the gestation limit, what about the rights of that patient? I mean, woman's right. A 26-year-old pregnancy of a married woman with 2 children. So she challenges in 2023, she goes before the Supreme Court. She says it's purely unplanned baby. And she said it is mentally agonizing for her and there are financial reasons also. She can't give a quality of life. So Justice Ragaratna and her fellow judge Hima Kohli, they decide that the woman's choice and woman's best interest is important here. So they allowed it. But then the case was referred by Aishwarya Bhati to the larger bench because she took an opinion from the medical board that the fetus had highest chance of survival. It was absolutely healthy. So the larger bench, headed by Chief Justice Chandrachud, reverses this and it says that how can we stop the heart when the fetus is viable? Isn't it amounting to murder? He said. In earlier cases, when the rape, I mean, in 1 month gap, a rape survivor's case, he had said that it is allowed. So Dr. Datar, who is leading a patient right movement, he said whether it is that case or this case, termination of pregnancy is about stopping the heart. The heart has to stop, he said. But then Justice Chandrachud gave another dimension. Of course, even Jindal Law School intervened here. But Justice Chandrachud gave a dimension saying that if the fetus has a chance of survival, let's not murder, give it up for adoption. So that was the solution that was innovated. And he also said that since there is already a legislation, the hands of the judiciary are tied. In normal cases, it cannot increase the abortion allowance limit beyond 24 weeks. Here it was 26 weeks. And it said that it cannot violate the legislative limit. Court cannot legislate since there is a doctrine of separation of power. So this is a case, which is mother of X. The other is the X case where she was a rape survivor. So in human rights concerns in terms of medical termination or abortion, access to health services is one, free from cruel treatment. I told you already, I don't want to repeat. Post-abortion medical services must be always available. Therefore, when we are talking about abortion, the kind of abortion, the right to body and determination of body, privacy and safety, personal liberty, all these dimensions of Article 21 come in. So in 2021 Amendment Act, medical decision, not too much medicalization, case-to-case basis, confidentiality of the woman, name not to be revealed, and then gestation limit to be increased from 24 to 20 to 24 weeks. These dimensions came, but we know. However, I have also cited certain judicial trends of the past. In 2016 in Madras, I told you the 18-year-old descent, once she attains 18 years, even though she is a rape survivor, she descends. And then in Zad case versus State of Bihar in 2017, abortion petition of rape survivor was rejected because of the gestation limit, because they approached the court very late. So we have a number of cases where they said that if they claimed the 13-year-old survivor of rape was denied abortion because it was told that it's not safe for her, but the safety is not decided by the court. 11 AIMS doctors had to examine and give a report. Then we also had a case whereby MTAP was not carried out by the doctor. No reason was provided for them. Petition was rejected due to lapse of 20 weeks. Again, we had the 20 weeks. So there was a strict legislative based in 10-year-old case. Again, in Alok Srivastava case, the survivor was pregnant for more than 20 weeks. So gestational limit has been the major process till the amendment came. But after the amendment came, we have seen that case to case basis within that gestation limit, decisions have been taken, even if it was slightly high. 28 weeks, 26 weeks were allowed, but not for abortion, but for what they called. Only one interesting case is the X case, which was very interesting. Beyond 30 weeks, it was allowed because the girl was going to have the trauma of keeping the child. And here is the case of a rape survivor, and that was again proved by medical dimensions. Therefore, today the emerging issue is, should the woman be allowed to abortion even if there is no medical risk? And 30-week allowed for a 14-year-old rape victim, what is the view? And marital rape and resulting pregnancy, is it possible? Because it was viewed as a forced pregnancy. And then accounting for maternal deaths due to unsafe abortion is another dimension. Accounting for maternal death due to unsafe abortion, whose responsibility is it? If it is private, there was a time when MTP Act, I mean, I have one slide on the evolution of MTP Act, that private hospitals were not allowed to do the MTP. And we don't have enough wherewithal in the public hospitals. So one of the amendments was that MTP was allowed. Again, it is driven by, is it driven, I mean, I don't conclude that, but is it driven by population control? Both, I think. State is encouraging it in a subtle way, but at the same time, it is also the choice of the couple because of economic reason. With more awareness and also experience, they may be deciding like that. However, if a woman is forced to bear children, if she chooses to bear children, it is different. I have many students of mine who say that I would love to have a few more children. That is different. She may have affordability, she may have the health, she may feel like there are no other members in the family who may be having children. So there may be many reasons. But if she doesn't choose, and if someone forces her at the threat of remarriage, at the threat of depriving certain benefits, then it is not allowed under the reproductive right framework. So abortion should be recognized as an aspect of woman's autonomy and self-determination, and then she should have also the access to such health service. Now, in case of surrogacy, we have different kind of reproductive dimensions, and there also child's right is also to be recognized, especially when internationally it is commissioned. And the surrogate mothers studies by National Law School and many other researchers show how badly they are ignored as people. So their reproductive rights is a major issue that has been researched by Tata Institute, I think National University Delhi, NLU Delhi, and NLS. So another is right to LGBT community of having a family. I knew a family, a fluid family, where the two gay couple and two lesbian couple came to an understanding. They were all law professors. MOU, whereby they would have assisted reproductive technology, and then have a child, and then the child will grow between two families. So right to parenting should be independent of biological capacity. That's why surrogacy is such an institution, adoption is an institution, and this kind of fluid family between gay and lesbian couple is another institution. So family should need not be necessarily associated with marriage. That's what Chief Justice at that time argued also, although they denied the concept of marriage in case of LGBT. So prevention of sexual abuse is very important. One thing that we saw in the London School of Economics study in Rajasthan, that Domestic Violence Act Prevention, I mean Prevention, Protection of Women Against Domestic Violence Act, PWDVA, has become the primary law through which reproductive rights occurring within household have been reported. So reproductive right violation, whether it is pregnant woman, about decisions of pregnancy or other violences or violations, they have been brought under this act. So this is a very powerful accompaniment to the reproductive right framework that we have in India. So concluding, I would like to summarize that reproductive rights are an essential and inalienable part of right to life under Indian Constitution. Legal framework includes MTP Act with all its avatars from 1971 to now. And women, this has to be also read with the Child Marriage Prohibition Act and POCSO Act, which is a major challenge. Now, the idea of marital rape within that framework and beyond that is another dimension that we have to see. Woman has complete control over her body and self-determination. Health of women has to be in the center in any policy, whether it is population control policy or reproductive justice illumination. Fostering reproductive rights is very important for development of the nation and for production process participation of women in national development. Therefore, it has to be ensured as women centric. To prevent senseless deaths of women, the approach through the Domestic Violence Prevention Act is very important, and also the integrated health policy, popularizing contraceptives, awareness about legality and safe abortion, making services accessible, improving post-abortion care, very, very important. Many women suffer because of this. Using community-based caregivers to destigmatize abortion by giving awareness and approach. So build the approach for inclusive health justice movement, which cannot be read piecemeal in terms of population control, but interconnect a web of rights of autonomy, self-determination, prevention of violence, and sanitizing the culture. Very important dimension. All of us act like cultural police. Sanitize that culture for human rights protection and prioritize reproductive justice with women's reproductive health in center. Women, not just women in center, women's health, which means the community, husband, uh, own family, joint family, and employer. All of us have responsibility to understand the nuances of female body and also to understand her reproductive health. That is what I have planned to share with you. Thank you very much for giving this opportunity in this very modern and very upscale and very advanced discussion. If there are any questions, I'll be happy to answer. Thank you once again.
It is my privilege to extend a heartfelt gratitude to all those who made this seminar a success. First and foremost, I express my sincere gratitude to Professor Dr. Shashikala Gurpur, ma'am, for sharing very valuable insights and expertise on the topic legal protection and challenge in reproductive rights, navigating population control and autonomy. A special thanks to our organizers, team members who work tirelessly behind the scenes to ensure everything runs smoothly. Your efforts are deeply appreciated. Last but not least, I extend my appreciation to all participants for their enthusiastic involvement and participation, which made this seminar more interactive and meaningful. With that, I conclude my words, hoping that today's seminar has been a fruitful experience for everyone. Thank you.
Thank you. Take care. Have a nice day. Good luck with the rest of the proceedings.
Thank you,
Thank you,
madam.
ma'am.
It was very
Yeah.
wonderful session.
Welcome. Please send me a photograph of
Sure, ma'am.
today's seminar, if possible. I'll just take for my own benefit. If
Definitely,
possible.
definitely, ma'am.
Yeah.
Definitely. We will have it
Uh,
certainly, ma'am.
and a report of how many attended and all that, just for
Sure,
our
ma'am.
own record,
Sure,
because
ma'am.
these things they help us a lot. Just give me 1 minute
Yes, yes, yes.
before I log off. Thanks for bearing with me. This takes a lot of time.
Madam, for your convenience, we have our offline attendees also. We will share the photographs of the same.
Yeah, sure. I'll just. I think my photo is also there. The quality is not that great, but I would request you to send me one.
Sure,
Thank
ma'am.
you. Wish you all the
Definitely.
best with the rest of the proceedings and with the
Thank
whole
you.
conference.
Thank
Great
you.
idea. Good luck.
Thank
Thank
you
you.
so
I'll
much.
log off. Okay.
Yes, yes,
Please
ma'am.
give my regards to Tarnath sir. Thank
Sure,
you.
sir. Sure.
The quality is not that great, but I would request you to send me one. Thank you. Wish you all the best with the rest of the proceedings and very good night. Thank you. I love that. Yes, please give my regards to that.
അവനെവിടെ മറ്റവനെവിടെ സാത്തിക്കോടെ സാത്തിക് 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 ജസ്റ്റ് കോൾ 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 എടാ ഫോൺ സെറ്റാക്കടാ പോടാ സ്ക്രീൻ ടൈം മറ്റേ ഇതാ ഓഫ് ആവില്ല തൊണ്ണൂറ്റൊന്ന്
It's now time to enrich our knowledge and to hear from our resource person. Over to you, ma'am.
Good morning, everyone. Good morning, everyone. Am I audible? So we are going to deal with medical legal perspectives on reproductive rights of women and the unborn fetus. So I've been asked to deal with the medical legal rights. Usually we talk only about the rights of women, and about the unborn fetus we usually tend to just forget. So here I'll be dealing with usually the intersection of the medicine and law in the reproductive rights, which is complex and often contentious. So involves balancing women's autonomy over the body with ethical, legal and medical considerations concerning the unborn fetus. Usually we talk about the ethical and the legal concerns, but the medical concerns are usually left out of the unborn fetus. So the legal framework governing reproductive rights varies across jurisdictions, reflecting diverse cultural, religious and societal perspectives. Now I'll be dealing under the following headings. One is women's rights and body autonomy. So under that we will be taking the rights to make decisions regarding pregnancy, contraception and abortion. Also the legal recognition of reproductive choices under the human rights law, fetal rights and legal personhood, which we usually ignore, and here it debates over when life begins and the legal status of fetus, protections granted to the unborn child in different legal systems. The next two things that I'll be considering is the medical ethics and legal implications, where the role of healthcare workers in abortion laws and reproductive health care, also the ethical dilemmas in late-term abortions and medical interventions. Coming to the last one, that is judicial and legislative developments, whereas the landmark court rulings affecting the reproductive rights and national and international legal framework influencing the policies. So under the women's right, first I will be talking about the Indian laws and international, then followed by the international laws. Under the Indian laws, first one I will be talking is the right to contraception under Article 21 and Medical Termination of Pregnancy Act and the amendment in 2021 and the Cell-Based Regulation Act of 2021. Coming to the rights of women under Indian law, the first one that I told you for Article 21, where they have said that no person shall be deprived of his life or personal liberty except according to the procedure established by law. Now, what do we understand from this importance for reproductive autonomy is the personal agents and self-determination, health and well-being, and legal and policy frameworks which have to go hand in hand to establish the right of the women in law. So, the justice framework will have the right of the child, the right to not have a child and right to have a child, both will go to the women, and the right to parent the child, one has to be safe and sustainable in sustainable communities. So, ensuring women's access to healthcare and reproductive rights. Now, when we say that, you need a comprehensive sexual and reproductive health education to the woman to decide upon whether to have a child, not have a child, whether to abort the fetus, and accessible healthcare facilities to the woman, safe and legal abortion services, even if she has to go for abortion, and availability of contraceptive methods of her choice. So now the question is, how does Article 21 protect the right to contraception? So in that you have the right to privacy and bodily autonomy, for which the Supreme Court of India in the K.S. Puttaswamy case of 2017 ruled that the right to make reproductive choices, including access to contraception, is part of personal liberty. I will not be going into the details because the time is short and I will be giving only the key points. So, right to reproductive health, when you say, it is the access to contraceptives and reproductive health services without coercion or discrimination. Next is marital and unmarried women's rights, where contraception is not limited to only married couples, and unmarried individuals also have the right to access birth control as part of their personal liberty. The next one is state responsibility, where the government must provide family planning programs, awareness, and access to safe contraceptive methods. And next is no forced sterilization, which is the most important, where any forced sterilization violates the Article 21 unless done with informed consent. Now, the landmark judgments that was supporting this right, that is women's rights for that is supporting Article 21, is the K.S. Puttaswamy case, which I already mentioned, then Suchita Srivastava versus Chandigarh administration, which held that the women's reproductive rights fall under personal liberty, and Devika Biswas and Union of India 2016, which highlighted the importance of safe and voluntary family planning. Also, the Article 21 protects persons' reproductive rights and has elevated the expression of right to life to a new level of significance. Now, this encompasses the right to sleep, dignified life, the privacy, the right to movement, and the right to health, among other things. Now, scenario of the right to health, among other things, in perspective of the reproductive rights, when we say that, you have to the question of whether the right to life encompasses the right to abortion also exists, because another significant point of contention is abortion debate is that a mother's right to terminate pregnancy versus the unborn child's right to life. Here, the right of an unborn child is a salient moot point, as only a person is guaranteed the right to life under Article 21 of Indian Constitution. Since the child is regarded as fetus in the mother's womb, it is unborn. A major issue also revolves around if an unborn child is a person. Second one that I would like to talk is under Indian laws is the MTP, or the Medical Termination of Pregnancy 1971 and amended in 2021. So why was the MTP Act that is amended? One is to reduce unsafe abortions and prevent maternal deaths, because unsafe abortions done after a period of a certain day usually puts the risk of the woman being dead during the abortions. To align with technological advances in medical science and to provide autonomy and dignity to women to make their reproductive choices. So, provisions of the Act, you have extension of gestation limit. So, what they have done is they have increased up to 20 weeks, and between 20 to 24 weeks, which is allowed for special category of women, like for example, survivors of rape, incest, minors, differently abled women on the advice of two, that is the regular registered medical practitioners. So beyond 24 weeks, if the person has to go for termination of pregnancy, then you are permitted only in cases of fetal abnormalities diagnosed by a medical board or a registered medical board. Also, confidentiality clause, you have the identity and personal details of the women seeking an abortion cannot be disclosed except to legally authorized person. Women's autonomy and reproductive rights, wherein again the amendment provides women with more control over their reproductive choices, ensuring safe and legal abortion access. Next is elimination of marital status discrimination. The phase, that is married women, was replaced with any woman, allowing married women to seek abortion under the unmarried women to seek that is abortion under the same conditions, and medical board for special cases where you have pregnancies beyond 24 weeks due to fetal abnormalities. A medical board must approve the abortion because it puts the woman under risk of death and medical mismanagement. Next is key improvements in the 2021 amendments where more women were covered, including the unmarried women. Confidentiality was protected, ensuring privacy. Extended gestation limit from 20 to 24 weeks. Medical board introduced for special cases and aligns with the modern and medical advancements for safer abortions. Now, if you compare the Medical Termination Pregnancy Act 1971 versus the 2021 amendment, you can see that all these things which I already told you, other than that, who can get an abortion is also there. Any woman, as I can show you here, including unmarried women, which was included. No clear provisions about confidentiality were there. Here, very strict confidentiality, like the identity cannot be disclosed to any other person, even if it is unmarried woman, and no specific mention of special category women. Here we have the special category women that's enlisted, and medical board requirement not applicable, and here you can see required for fetal abnormalities beyond 24 weeks, and you can see marital status considerations also given an equal status of unmarried and the married women, especially in case of reproductive rights. Then medical legal issues arising from the situations. Now, what are the issues that will arise medically? You have to see, that is termination without consent or appropriate counseling. That is, sometimes the family may force them, or they may force that is manipulated into abortions or the termination of pregnancy. So, without appropriate counseling, without talking to a counselor, they cannot go ahead with the termination. So, carrying on with the pregnancy even after MTP, what happens is sometimes MTP is attempted, but then it does not terminate. You cannot terminate the pregnancy, and the pregnant lady will have to deliver the child. Tomorrow, if the child comes to know that he was tried to be terminated and he has survived, you can understand the emotional issue that the woman with and the child both will face it, and this could be classified as a negligence act from a legal standpoint, not only legal standpoint, both psychological and medical standpoint as well. So, faulty procedures are one of the severe causes of failing MTP. Not only faulty causes, supposedly after 24 weeks also sometimes it has been attempted, because previously for some reason they wouldn't have gone for MTP after 24 weeks, and they will try all different methods because registered practitioners will not accept to do beyond 24 weeks of MTP. Then MTP and incorrect diagnosis. Sometimes what happens is there will be incorrect diagnosis, especially in case of ectopic pregnancies which are frequently missed. So usually a pregnancy initial stages is detected by ultrasound scanning. So supposedly it's missed in the areas that they were scanned. Supposedly there is an ectopic pregnancy that is away from where actually the child should be present, and these are called as ectopic pregnancies. Then the woman's life would be in danger as a result, which would warrant illegal, that means legal action. Then comes morbidity and even mortality after the procedure can be attributed to neglect and improper follow-up treatment for all the causes stated above. And that is primary gravida, that is MTP, raises serious ethical issues. What is primary gravida? I am sure you all know about it. It's the first time pregnancy of a woman. So you can see the physical and mental agony she experienced with the first pregnancy cannot be compensated for, because it is the most welcome addition to a family, usually when it goes in the right way. And for some other reason other than any social causes or family reasons you have to abort the child, so it becomes a lot of emotional and psychological stress to the woman. Also, there is a potential that an infection would cause morbidity and possibly secondary infertility in the future, which would be a cure for womanhood in the contemporary society. Coming to rights of women, the third one that I would like to talk under Indian law is the Surrogacy Law Act, that is Surrogacy Regulation Act 2021, which aims to regulate surrogacy practices, protect surrogate mothers, and ensure ethical procedures in assisted reproduction. Before 2021, we all know that people who are healthy, the women who are healthy but busy, all went for surrogacy. Many of my friends also just because they are surgeons, just because they are doctors, and they don't have time for pregnancy, they all have gone into surrogacy and they are delivered and they are happy today. But at the same time, any practice that is beyond a limit, which crosses all boundary and becomes misuse, it has to be stopped. So for that, 2021 Surrogacy Regulation Act is perfect. So here, the definition is a practice where a woman gives birth to a child for an intending couple with the intention to hand over the child after the birth to the intending couple. So, intending couple, when we say they want the child, and hence they are asking for surrogacy because they have failed all types of methods to conceive a child. So, regulation of surrogacy prohibits commercial surrogacy. So, when I said misuse, after a certain period when money is involved, it becomes commercial surrogacy. And then permits altruistic surrogacy for intending couples who suffer from proven infertility. It permits it, and rights of surrogate child. Now, what are the rights of a surrogate child will be of utmost importance. Their child born out of surrogacy procedure shall be deemed to be a biological child of the intending couple or intending woman. So, that becomes a question. Prohibition of abortion at any stage of surrogacy except in condition as may be prescribed, which we will see later. Eligibility criteria for a surrogate mother, we have to know at the same time. Close relative of the intending couple, it should be a married woman having a child of her own, age between 25 to 35 years, so that the woman will be quite mature to handle the pregnancy as well as the child later. Possess a certificate of medical and psychological fitness for surrogacy, because it's not only medical fitness but also psychological fitness for the woman who is going to bear the child and take care of the child for a little while later. The surrogate mother cannot provide her own gametes for surrogacy. Then it does not become surrogacy, it becomes her own child. So her gametes cannot be given for surrogacy. So what are the three key provisions? Ban on commercial surrogacy, I told you. That prohibits commercial surrogacy, allows only altruistic surrogacy. That is, allows only couples which cannot conceive over a period of time to go for surrogacy, where there is no monetary compensation involved except for medical expenses. But this does not usually happen. I'm sure there will be medical, that is monetary compensation, because the lady loses a lot of time and effort. Everybody's time is very important. So eligibility criteria for Indian parents, only Indian married couples, that is heterosexuals, with proven infertility can opt for surrogacy. A woman must be aged 23 to 50 years and a man 26 to 55 years for as Indian patients, and they should be proven, they should give the enough benefit of doubt that they cannot go for conceiving. And then conditions for surrogate mother, you have the surrogate must be close relative of the intended couples, and then she must be married woman. I have already told you that, and she can be a surrogate only once in a lifetime. She cannot conceive again. Then comes to rights of surrogate child. The right born through surrogacy will have the same rights as the biological child, but for the intended couples. Regulation and penalties. You have establishes, that is national and state surrogacy boards, to oversee the practices. Otherwise, again, once it goes commercial, then it goes again beyond boundary, because monetary benefits will definitely be involved, whether it is over the table or under the table. So violation of the act can lead to imprisonment up to 10 years and fines. And then the controversies and criticisms usually is exclusion of the LGBTQ couples and single parents for surrogacy. Of course, they can go for adoption. Adoption is always a choice, but surrogacy is excluded for LGBTQ plus and single couples. Close relative condition restricts surrogate, that is availability, and concerns over lack of compensation for surrogate mother. So there are usually the surrogate mothers will not agree to bear the child whether if they are not compensated for. Now these are the Indian laws that I have taken, permitting the time that has been given to me. Coming to the international laws, we have the Roe versus Wade in the US, which was overturned by Dobbs versus Jackson in 2022, wherein the Roe versus Wade, it was told that the abortion is the woman's choice of her body, and she can proceed if it is her choice, and the state did not have much rights over it. Now the Dobbs versus Jackson, where the Supreme Court overturned the previous law, protects for abortion rights, allowing individual states to set for abortion laws. So we know that they have state laws in the US. It's not like Indian laws where one law will govern all the country. They have provincial laws and state laws. So state level bans and restrictions in their places, where many conservative states have enacted total or near total abortion bans, with some exceptions for rape, incest, or the life of the mother. Increased legal battles. Now, because of this, what has happened? There are so many legal battles that are ensured. Lawsuits have been filed challenging restrictive abortion laws, and some states have added constitutional protections for abortion. Also, travel for abortion access. So, because of this, the people from the province where the abortion is banned, they travel to other states where it is legal, and hence there is abortion travel, that is, you can say abortion tourism or medical tourism for abortion. So, people in states with bans often travel to other states or countries where abortion remains legal. Now, they vary worldwide, not only in US but other countries also. Abortion laws are totally different. Countries with strong abortion rights, that are Canada, no federal restrictions on abortion, it's regulated like any other medical procedure. France and Germany, it's legal up to 12 weeks with conditions of course, and later abortions allowed in special cases. UK, it's legal up to 24 weeks and exceptions beyond that for medical reasons. Countries with severe restrictions or total bans are El Salvador and Nicaragua, where total bans with prison sentences for those who get or assisted abortions. And then Poland, you have highly restrictive, only allowing abortions in case of rape, incest, or life-threatening circumstances. In Malta, you have near total ban, but a recent law allows abortion when the mother's life is at risk. So you have heard of people like countries where abortion rights have expanded recently because of various different cases where abortion was not allowed even when the mother's health was at risk. So Ireland in 2018 legalized abortion via referendum, reversing the strict bans. Ireland was one of the countries. Argentina legalized abortion up to 14 weeks, and Mexico from 2021 to 2023, their Supreme Court decriminalized abortion statewide through access that is varies by state. Now the WHO guidelines on reproductive health. When we talk about international laws, we have to talk about the WHO and what they speak about the reproductive health. So they provide comprehensive guidelines on reproductive health, including abortion, contraception, maternal health, and sexual health. So first one, what we are going to see is the abortion care and access, where safe and legal abortion. You can see WHO, which supports the decriminalization of abortion and recommends ensuring access to safe procedures, because we are not talking about developed countries, we are not talking about developing countries. We also have to take concern of the still that is below poverty level countries, like in many states in many countries in South Africa and African regions, in South American regions, where there are very hardly any few safety procedures for abortion. Then self-managed abortions, where you see medications like mifepristone and misoprostol are considered safe for self-managed abortion of up to 12 weeks of pregnancy. So many people have attempted this, and they have gone into bleeding, heavy bleeding, and then get admitted and go into all the different infections and all the contraindicated status for their MPPs. No mandatory waiting periods, where WHO discourages delays or unnecessary requirements. Example, parental consent, waiting periods that can hinder timely abortion care. Then you have contraceptive access and family planning, which is universal access to contraceptives. You have WHO advocates for affordable, voluntary access to birth control pills, IUDs and implants or condoms, etc. Informed choice, individuals should have the right to choose contraceptive methods based on personal needs without coercion. So no coercing them, the family coerces them, the family manipulates them. So they should be given awareness, they should be given knowledge, and then they should be asked about what is their consent and what are their choices. Then emergency contraception. When you say emergency contraception, it should be available without prescription to prevent unintended pregnancies. So without prescription or over-the-counter drugs also should not be taken, especially when it comes to termination of pregnancies. Then comes maternal and newborn health. Respectful maternity care has to be given, which promotes dignified, non-discriminatory care for the pregnant lady, and skilled birth attendance has to be done, ensuring midwives, doctors, or any skilled personnel attend all births to reduce the maternal mortality rate. Now, postnatal care, you have critical support within 24 hours of birth and follow-up care for mother and the baby. Comprehensive sexual education and rights. Now, all the three things will fall into place only when you give them the right education, or the comprehensive sexual education and rights, as well as the reproductive education about the reproduction. Next, sexual and reproductive rights. Everyone should have the right to make informed decisions about their bodies. Sex education for youth. that is WHO supports comprehensive evidence-based sex education in schools, gender-based violence prevention, which includes legal protections and medical support for the survivors. Now the last one among your international laws where the right to perspective of the women comes, you have the European abortion laws, which is, I told you, varied country restrictions. You can compare here the legal age, how it is different in different countries of Europe, where abortion is widely accessible, often within a gestational period. So these are the countries which have very liberal abortion laws. As you can see here, 14 weeks, 12 weeks, 24 weeks for UK, which I told. So this is one of the list you can see here. Then these are some of the countries with moderate restrictions where legal in some cases but with stricter requirements, and they have put clause for all the MTPs. Then countries with severe restrictions, Poland, Hungary, Slovakia, Malta and Andorra, where some places also have total ban where no exceptions even for rape or risk of the mother. So in such countries, you cannot go for MTP, termination of pregnancy, even if the mother is at risk or even if it is the delivery is because of secondary to rape. Now, trend in European abortion laws, expanding rights, usually Spain, France and Ireland, they have recently liberalized their abortion laws. Backlash and restrictions, Poland and Hungary have tightened abortion access and medical tourism. People from restricted countries, they often travel to places like Germany or Netherlands for abortions. Now, all this is taking place because in US and other countries, Western countries, teen pregnancies have taken very high rates. Teen pregnancies are very high, and these kids are not even aware how to take care of themselves, forget about the fetus in their womb or after delivery. So because of this, it is a two-edged sword, let me tell you, because the teen, after giving birth to a child, how good can they take care of the child? They themselves are not established in life. The child will also grow just like them, and the fetus in the stomach, if they are not aborted, what happens? They go for pregnancy, isn't it? But the laws are such that they are putting a stop to abortion so that the children take care that they don't go for pregnancy at all, and they take care of the that is birth control mechanisms before they go for pregnancies. Next, we have dealt with the rights of the women so far. Now, the rights of the unborn fetus, again I will talk in terms of Indian perspective and international perspective. So, in an Indian perspective, you have no explicit legal personhood for the child. When you say no explicit legalhood, at the same time they have given some few rights to the fetus as well. So, the unborn fetus does not have independent legal personhood under Indian law because a fetus does not become a person until they are born. So, abortion rights, MPP, which I have already spoken about, this now allows abortion under the specific conditions which are already stated. Then inheritance rights now puts the fetus in power as a individual, wherein a fetus in the womb at the time of a father's death is considered a legal heir provided it is born alive. I am sure you all agree with this, because if the mother is pregnant, it becomes a legal heir of the father who has died, even though the child is within the age of 12 weeks. Then fetal harm and legal consequences. IPC section 312 and 316 criminalizes causing miscarriage or harm to an unborn child unless done lawfully, and PNDT Act 1994 prohibits sex determination tests to prevent female feticide. So one of the main causes of feticide is because it is a female child. All over India, we know that the rates are very high. Still, people go for infanticide when it is a female child, if they have diagnosed in ultrasound. But there are many times, there are many false positive as well as false negative results when you see in ultrasound scanning about the sex determination of children. So surrogacy and ART regulations, where we see legal provisions exist for embryos in surrogacy agreements under Surrogacy Regulation Act 2021 and Assisted Reproductive Technology Act in 2021. Also, we should always remember that now we can actually isolate eggs and keep it for fertility further. So new laws have to be governed for the same. Also, next one is the fetal viability under MTP Act. Now, what is fetal viability? It is refers to which stage of that is the stage at which the fetus can survive outside the womb, typically around 24 to 28 weeks of gestation. However, under MTP Act in India, the legal framework for abortion is based on gestational limits rather than strict viability. And here now we know that it was up to 20 weeks. Now it is 22, 24 weeks, extended limit for special categories, beyond 24 weeks, allowed only in cases of severe fetal abnormalities, but with the approval of the medical board. The board has to constitute gynecologists, radiologists, and pediatricians. So all these things together, they have to form a team, and then only you will go for termination beyond 24 weeks if it is very much serious disability of the mother. Then no absolute right to abortion. Unlike some countries where viability determines abortion limits, in India's MPP Act does not explicitly use viability as a cutoff, but instead applies gestation limits and medical assessments. So it becomes very custom based for each person. So if this person is medically viable to go for abortion and she really requires for her health concerns, then only the medical board will give the permit and they can go ahead with the termination. Courts have sometimes granted abortion beyond 24 weeks in cases of severe fetal anomalies or risk of the mother's life. Not only risk of the mother's life, nowadays you can see there are advanced diagnostic techniques where you can see if the person is suffering from any syndromes or any other methods that is medical issues, then the fetus can be terminated because it is going to be a issue for the child itself. Then PCPNDT Act, that is Prevention of Female Feticide Act, which has to be told here, which was enacted to prevent female feticide and regulate the misuse of prenatal diagnostic techniques. So basically they put a ban on diagnosing the sex determination of a child. So objective was to prohibit sex selection. Now sex determination, the next thing was sex selection, because most of them wanted a male hire for themselves before and after conception, both it was banned. To prevent misuse of ultrasound and other diagnostic techniques for determining sex of the fetus, to impose penalties for violations and ensure strict regulation of genetic clinics and labs. Coming to provisions, ban on sex determination. No person, including medical professionals, can conduct or assist in prenatal sex determination. Now anybody else, sometimes what happens is, it is just ultrasound techniques, so there will be an assistant next to them. So they will also learn how to check the medical technician or someone. So they also cannot determine sex. So for everyone, including medical practitioners, their assistants, the technicians, nobody is allowed to check for prenatal sex determination. Regulation of diagnostic clinics. Clinics using ultrasound, amniocentesis and other techniques must be registered under the Act. So under amniocentesis also you can determine, there are many other markers also, whether the child is male or female. Prohibition on advertising, any form of advertisement promoting sex determination is illegal. That is why previously you could see boards that sex determination here in small villages, but now all such boards are also missing and they are illegal. So what are the penalties? Usually first it's an offence and 3 years imprisonment, fine of 10,000, and subsequent offences harsher penalties including cancellation of medical license. Then amendments and strengthening of the law. 2003 amendment strengthened implementation of making ultrasound centers accountable. So you can see there may be a raid any time to that place, ultrasound centers, if there is any sex determination that is going on surprise inspections by any fractions of the society, then if they are accountable, they will be also fined or punished. Strict monitoring, that is establishment of regulatory bodies at state and district levels, and decoy operations, permitted undercover operations to catch the offenders. As I told you, not only surprise inspections, there will be decoy operations to catch such offenders. Now coming to the international perspectives, as I told you always, the post-Dobbs ruling. What was the significant changes in the fetal rights? So US laws particularly had fetal rights was a state interest in the US. So the state said it was their right to decide whether the abortions are permitted or not, and the women were always saying that it is their right. So the Dobbs versus Jackson Women Health Organization decision overturned, that is Doe and Wade versus Wade, and Planned Parenthood versus Casey in 1992. The ruling eliminated federal constitutional right of abortion, allowing individual US states to regulate or ban abortion. And variation in US state laws, some states protect abortion rights, some others ban or heavily restrict abortion, and some states define fetal personhood. They have defined for fetal personhood, giving legal rights to unborn in contexts like inheritance or wrongful death cases. So, Then conflicts between fetal rights and maternal rights, which is an ongoing, dispute since ages. So some laws restrict abortion after viability, and while others ban it at conception. And legal debates continue over fetal personhood, maternal autonomy, and medical exceptions. Now you can see here some of the countries grant limited fetal rights. You can see the different laws and comparison. This is very easy to compare. When you see here, you have a complete picture wherein you can see in United States it varies. I told you they have state laws and provincial laws. Some recognize fetal personhood and some others don't. Whereas in France you can see no legal personhood before birth and legal up to 14 weeks, that is abortion laws, and strict penalties for illegal abortions also can be seen. So all these things, when you see under this perspective, you have to be careful about the different countries that have different types of abortion laws and medical termination of pregnancy laws. Under the international perspective, also you have some European countries grant limited fetal rights, like US and Germany. Canada and UK prioritize maternal rights with minimal fetal recognition. Now when you say pregnant women versus the unborn fetus, if the pregnant woman can say it is my body and my choice, the unborn fetus also can say the same, right? Just that it does not have a mouth to speak. So let us see which are the arguments in favor of the abortion, and let us see which are not in favor of the abortion rights. First one, the unborn child versus women's rights. You have paramount consideration to the mother, need to consider the mother's well-being, privacy and dignity. Then you have the conscious decision by the woman, wherein the woman has taken a conscious decision not to have a baby, and then this decision should be respected, taking into account the woman's mental condition, her inability to care for her unborn child. Justice B.V. Nagaratna emphasized that the women's decision should be respected and consideration of the women's socio-economic situation is a must. Also, she points out that this is not the case of a viable baby being born or unborn, and priority should be given to the interests of the woman. So there are two schools of thoughts. One school of thought says that the woman should be given more importance because it's her body, her decision, and she has to decide finally whether to go in for carrying the baby or continue the pregnancy or not. Then unborn child versus women's rights. You have the arguments that are against abortion, wherein the rights of the unborn child are of paramount, and women does not have an absolute right to autonomy to exercise her reproductive rights in a way that would compromise the rights of the unborn child. When I said right to body, as equally both the woman have the child have right to body. Reference to the MPP Act of 2021. I have already explained the same thing, whereas except in exceptional circumstances, which is allowed only if necessary to save the life of the mother or in cases of fatal deformity detected in the fetus, like any syndromes or any other medical issues. So viable baby and state responsibility. If there is a viable baby, the relief cannot be one-sided. The state has responsibility to protect the life of a child, especially since the medical opinion suggests a chance of survival. Then comes the Parliament's authority or the reproductive rights. So especially when it comes to teen pregnancies, usually the countries waken up, and when the MPPs are going on as any other medical procedures, you can see that it becomes the Parliament decides the authority to regulate reproductive rights and determine the condition under which the abortion is permissible. Now Justice Hima Kohli agrees that women should not be permitted to terminate the pregnancies. We have seen two people who have given different opinions. So her opinion aligns with the idea that the rights of the unborn child and the state's responsibility should be considered. So here you can see the comparison between women's reproductive rights and the rights of the unborn fetus, both for legal status, the abortion laws, bodily autonomy, medical termination, ethical considerations and judicial rulings. So you can see that there is a totally different conception for both because everyone has their own perspective. Now what are the main setbacks and what is the way forward? So when we keep all these things in mind, we have to see what are the setbacks, both considering the women's health as well as the fetal health in mind, also the way forward. So you can see what are the different setbacks here. Now in our country especially, despite 30 years of progressive legislation, most Indian women still lack access to safe abortion procedures. In 2002 and 2003, Medical MPP 1971 was revised, 2021 sorry, to improve the safety of services. No legitimate legal justification for numerous complex rules and regulations surrounding abortions. We know that you cannot give one precise or any other reasons because everybody has different perspectives. Abortion is only considered safe when it is made available upon a woman's desire, widely available, inexpensive and accessible to the woman. So you can see here once again, we have put the key issues, the examples and the importance for reproductive rights, the maternal health, the sexual health, menstrual health, mental health, preventive care and and gender-based violence, because it is not one issue that has to be addressed, but all the following that has to be addressed for the woman and the child. Now, how will you go ahead with balancing the rights of both the child as well as the fetus? Finding a common ground. So I told you custom-based, that each patient care has to be dealt with separately, and each patient has to be taken as a new patient. And discussions around reproductive health can benefit from collaborative approaches that recognize the interests of both women and unborn fetus, fostering a conversation that seeks solution rather than exacerbating the divisions. Now we should know that I told you the fetus becomes part of a mother, so they are not divided; they are a single individual. So we have to balance that act, and you cannot increase the divisions. Rather, you have to take solution as a single problem. And inclusive policies. How do you include the policies? That is, effective reproductive health policies should consider the varied perspectives of women, including their needs for autonomy, healthcare access and support during pregnancy and childbirth, as well as ethical considerations surrounding fetal welfare. Now in this time, we can say that we always say for all the disorders, prevention is better than cure. So there are so many types of prevention of pregnancy. Why not go for such preventions rather than go for MTPs and then ruin your own health, then put the fetus and then go into emotional crisis, psychological crisis and medical crisis. So instead of that, inclusive policies, and find a better solution for the same thing. So public health perspectives. So the government has to look at the public health perspective as a whole. So many advocates argue that supporting women's reproductive rights is crucial not only for women's health but also for the well-being of children and families. Also, access to comprehensive reproductive health care is linked to better health outcomes for mothers and the children alike. So to conclude, the discourse on reproductive rights of women and right of unborn fetus is complex and requires consideration of ethical, legal, medical and personal dimensions. And also, you have to strike a balance that respects rights and health needs of women with moral implications of fetal rights. Also, effective dialogue, education and advocacy plays very important roles in navigating these sensitive issues while aiming to uphold the dignity and rights of all that are involved. Thank you. So you deserve to parent your child without fear that he or she will not be hurt or killed, and freedom for violence is reproductive justice. Thank you very much. These are my designations. Thank you. Any questions?
It is my privilege to extend a heartfelt gratitude to all those who made this seminar a success. First and foremost, I express my sincere gratitude to Dr. Kumudha Rao, ma'am, for sharing very valuable insights and expertise on medico-legal perspective on reproductive rights of women and the unborn fetus. A special thanks to our organizers and team members who work tirelessly behind the scenes to ensure everything runs smoothly. Your efforts are deeply appreciated. Last but not the least, I extend my appreciation to all the participants for their enthusiastic involvement. With that, I conclude my words, hoping that today's seminar has been a fruitful experience for everyone. Thank you. Now, I kindly request all to join the respective classes for the paper presentations. Thank you.